Hey guys, this is day 12 of the Alex Murdaugh trial. Obviously, Court TV was not up and ready to go, so we are pulling in law and crime. I am going to my BOCC meeting, so I am going to just be playing this from the house for each of you guys to see what goes on in the court. Law and crime are pulling from the same sources that I'm able to pull from, anyways, so we're going to be pulling from them today. I should have this back as soon as we can get this over to um, court TV. We will, but at least you'll be able to see Alec show up for his court proceedings, and then we will go. And I've got to run. Guys, I will see you later this afternoon once my meetings are complete. So take care and God bless.
God damn it! When he walks by and says nothing, I won't be able to hear it. Sorry. Okay, let's do it the traffic light. Big old black van, Mike. I heard it nerve ending. Is that it? That's it. Cameron, you gonna take that one? I will. That Murdaugh's brother is real tall.
That is the blue tarp that we located inside the bedroom in the inside the closet inside the bedroom.
Okay. And what was that tarp located in?
A storage container.
Were there any items in the storage container?
There were miscellaneous dishes underneath the tarp.
Please be seated.
All right. Good morning. Any further comment or argument regarding the witness from yesterday, the last Ms. Smith? Ms.
Yes,
Smith's testimony, yes.
Yes, Your Honor, we did get a transcript, overnight transcript of her testimony. It's very rough, but on recross, if you will, at page 90, I asked her, have you ever seen this rain jacket before? And the rain jacket, I'd put a photograph into evidence, Defense Exhibit 87, and she says no. Alex Murdaugh had that rain jacket with him when he came to Ms. Libby's home on the morning, I believe, a few days after the funeral. She says no. And then I asked her, have you ever been in this closet before? Pointing to the state's exhibit where they showed something folded up. She says, no, I haven't. And then I asked her, what that is folded up there, do you? And she says, correct. And then I asked her if what's in that closet is this rain jacket, you've never seen Alex Murdaugh with this garment before, have you? And she says, no, I haven't. And that's the testimony and that's on page 90 of the transcript that we got last night. Well, this morning we got it, Your Honor.
All right. From the state.
Your Honor, again, it is fairly rough to try to read some of this, but as I would go back and point to page 65, where the witness was asked to describe it, again, she talked about observing Alex coming to the house at an unusual time, a few days after the murders, carrying a bundled up blue vinyl item. And then she was shown a picture with it in that closet where it was recovered. And she said, did you see a blue object in the center? Yes. Does it appear to look like the object you've described? Yes. You're saying yes. Is it the blue vinyl? This appears to be the same thing you saw the defendant holding. It looks so, yes. And of course, then you had subsequent testimony from the crime scene investigator about recovering that very item that proved to be the raincoat, which of course, if you hold it out, is very, very large and very much like a tarp. So I think many of these issues that the defense is raising are issues for jury argument and go to weight, not admissibility.
The witness testified under direct examination that the item in evidence appeared to be what Mr. Murdaugh brought into the house that night. She said he was carrying something, it was in his arms. She said it was blue something, that it looked something like a tarp, a blue something, but she did not know what it was. It wasn't opened up and she could not clearly identify the item either as a tarp, as was shown by Mr. Griffin, or as a raincoat. She testified that the item presented was consistent in appearance with what Mr. Murdaugh brought into the home that night and what was shown in the photograph that was taken. Certainly, Mr. Griffin did, I would say, an effective job in cross-examination and raising questions as to the credibility of the witness. That is the exact job that a jury has to do. That is weigh the credibility of the witness and to determine whether the testimony was consistent on the one hand or inconsistent on the other hand. And this witness's testimony was consistent on the one hand and inconsistent on the other hand, but that does not make the testimony inadmissible. It doesn't render the evidence inadmissible. Whether evidence can be made relevant and admissible through inference. The inferences can be drawn from the evidence. It is circumstantial evidence that is a part of this case, which suggests a fact by implication or inference. It could be the appearance of the scene of a crime, testimony that suggests a link to the crime, and if it can, facts can be proven through inference. The facts and circumstances through which the witness testified on direct and cross-examination and taking the testimony as a whole. The item is in evidence. I find that it is relevant in that it creates, through inference, facts that are in dispute in this case. And I deny the motion to strike her testimony, if that's what the motion is. I deny the motion to declare her testimony as being irrelevant. And the latest motion was that it's prejudicial or the results of an examination of the item is prejudicial. Of course, we haven't had that testimony, but we have an item in evidence. We have many items in evidence. We have, items are being placed in evidence as, what number are we up to now? 400, 500? 400 items of evidence. Witnesses have been questioned as to whether they walked the side of the roadway to see whether anything was along the roadway other than a cell phone. Witnesses have been questioned as to whether or not they looked down the drain pipe or of a tub or shower, or just any number of questions been posed with the witness to the witnesses as it relates to discovery of evidence. This evidence was obtained through a search warrant. It is in evidence and it's there for the jury's consideration. Certainly, once an item is in evidence, and as long as a chain of custody has been established, there can be testimony as to what it is or of what significance is it. And that's the stage we are here in these proceedings. And I deny the motion to strike it, to find it for relevance purposes or because it creates or presents evidence favorable to the state, which automatically means it would be prejudicial to the defendant. Yes, sir.
Your Honor, just to clarify, the motion that the defense made late yesterday afternoon was in advance of Megan Fletcher, SLED agent Megan Fletcher's testimony that there's GSR on the blue rain jacket. And so the motion was to prevent her from testifying as to the GSR, the testing of the rain jacket, under 403. I understand the court's ruling. I don't think they're going to call Ms. Fletcher first, but when she does take the stand, we will for the record, renew the objection. And
No, that's just a point. You say you object under 403, claiming it's more prejudicial than probative. And that's a fact-finding issue. That's an issue to be weighed not by me, but by the fact finder. I am to determine whether it's more prejudicial than probative. It's relevant. It's apparently important enough that the state seeks to use it. All evidence adverse to the defendant can be considered to be prejudicial. But I do not find where any prejudice is substantially outweighs its probative value. So I deny that motion. I certainly respect your objection. The witness sort of all over the place with her testimony and appeared to be confused. I'm not sure she obviously was not of the same level of unable to articulate her thoughts through her emotions and through this setting of being examined and cross-examined in this case. But the testimony taken as a whole shows that she identified the item as being consistent with what she thought the defendant brought in. She said he had something in it. It's important enough for her to contact someone about it, and that landed her here on the witness stand, among other things, other reasons. But everything is noted and protected for the record.
Thank you.
Yes, sir. We're ready for the jury.
Stay ready.
Proceed, Your Honor.
All right. Regarding juror number 729, I spoke with him briefly. So I guess I've now said him. Spoke with that juror briefly this morning, and he's going to stay with us. He's made some arrangements, he thinks, with his job, and he's going to stay with us. We have another juror, however, juror number 548, who made contact with the court and says that he's at the emergency room this morning. We don't know what his situation is. He is an alternate juror, and we'll need to proceed without him. Juror number 548. As time passes, attrition kicks in. We've done well thus far. This will be the first juror who will be excused. He's at the emergency room. We don't know how long he'll be there. We're not going to delay the trial.
The jury is present, sir.
All right, very good. Thank you. Good morning. Day number 12? Day number 12. 11. Day number 11. You sure? 12. I said 12, yeah. Day number 12, state's case. No, 5 days in a week. 5. You may proceed, state's case.
Thank you, Your Honor. May it please the court. The state would call Jeannie Seconder.
Renew our objection to this witness's question. And
Yes, sir.
thank you.
Good morning. Left hand on the belly. Do you affirm the testimony about to give report in this trial shall be the truth so help you God? State your name again for the record. When you take the seat, spell your last name, please.
My name is Jeannie Seckinger, Seckinger.
Ms. Seconder, how are you doing today?
I'm good.
Awesome. Tell the jury a little bit about yourself. If you could, just kind of introduce yourself. Where'd you grow up? Where'd you go to school, Joy?
I grew up in Hampton, South Carolina, graduated from Wayne Hampton, went to the University of South Carolina where I got my BS in accounting. After that, I worked a number of years in public accounting. Then I transferred into as a financial analyst with Westinghouse in Hampton. And after the birth of my second child, I stayed home and worked for my husband just a few years. And in 1999, I came to work with the firm on a part-time basis, doing some special projects, and have not left. And that job has grown since that time till I was over all the business aspects and financial aspects of the law firm.
All right. Which law firm are you talking about?
Peters, Murdaugh, Parker, Elstrop, Dietrich.
Is that PMPED?
That's correct.
Is that what the firm is currently known, or is it known by a different name?
We are now a separate entity that we've reorganized as Parker Law Group LLP.
And do you know the defendant, Alex Murdaugh, over there?
I do.
Do you see him in the courtroom?
I do.
Can you identify him, please?
He's in the blue jacket and white shirt sitting between Jim and Dick.
Your Honor, can the record reflect she's identified the defendant?
Yes.
Was he a partner in the law firm you're speaking of?
He was.
Is he a partner anymore?
No,
And we're going to talk about some of those things, the reasons for that here today. Is that correct?
that's correct.
All right. So I'm going to call it PMPED, what we're talking about. Is that fair?
That's fair.
All right. Well, tell me, you talked a little bit about your role in PMPED. What would you consider your role, or how would you define your role, particularly as we're moving into June of 2021?
At that point, I would be CFO/COO, basically overall office management and all financial affairs of the office, over hiring and firing, HR, just any, like I said, any business aspect of the firm.
So CFO, that means what?
Chief Financial Officer,
And COO, that means what?
Chief Operating Officer. And so I kind of combine those jobs.
Are you a lawyer?
I'm not.
Or are you an accountant?
I am.
Do you have a CPA?
I do.
You said you started working for the firm when?
August of '99.
And then when did, was Alec working there at that time, the defendant?
I think Alec came to work the year after me.
Okay. Did you know him prior to that?
I did. I've known Alec since I was 16 years old in high school.
Y'all went to high school together?
We did. He's a few years behind me, but we were in the same school.
And you worked with Alec at the law firm up until September of 2021?
I did.
Let's talk a little bit, if we could, about the law firm itself. And tell me a little bit about the financial structure of the law firm. How does it work that fees come into the law firm, and how do they get dispersed at the end of the year? Can you explain that to the jury a little bit?
Yes. So every fee that any attorney makes is property of the law firm. It comes into the law firm and goes into the law firm's accounts. And it is sitting in kind of what we call a holding account that we just amass the money. We have another account called the operating account that we use to pay the daily bills of the law firm, wages, insurance, office supplies, etc. Each attorney in the law firm is also an employee of the law firm. They receive a paycheck just like most people do, with W-2 taxes taken out and W-2 at the end of the year. When we get to the end of the year, we figure the net profit of the law firm, basically everything brought in and everything paid out to date. And we distribute that money based off a ratio of what that attorney brought in to total. So if an attorney brought in 10%, he's going to get roughly 10% of the net income at the end of the year. And we do that in a form of a bonus one time at the end of the year.
When is that bonus typically paid?
That bonus is typically paid the last week of December every year.
And is that for most cases and most of the partners, as we're going to call them in the law firm, is that the vast majority of their compensation of the year, is getting it all in one lump sum at the end of the year in December?
That's correct. They receive a salary of $125 through the year that they're paid every 2 weeks, but the vast majority of their money comes in that one bonus check.
Okay. Now, you mentioned there was a salary. Looking back at June of 2021, what were the partners in the law firm, what were they getting as a salary?
$125,000 a year.
All right, $125,000, and that was broken up into checks like
26 times a year, yes.
Okay. And then, so that has to be accounted for before the bonuses are paid, correct?
That's correct.
Salaries not only for the partners, but also for all the other employees.
That's correct, all staff.
All right, and is there other overhead that has to be accounted for out of the fees before that bonus can be paid?
Yes, all the other overhead is the basic operating expenditures like I discussed: rent for the building, insurance coverage for the employees, office supplies, case costs that we advance for our clients. We pay things as we go during the case. We pay experts, record fees. All of that is part of overhead. So after everything that's paid, everything brought in, after everything that's paid out is what we call that net income that we distribute.
Is there some sort of 7.5% fund or offset that has to be accounted for as well before the bonus is paid?
There is. We have what we call a 7.5% kind of profit sharing, and everybody takes their gross fees less their portion of overhead. We take overhead and divide it by the number of partners. And so you would take, let's just use numbers. If your gross fees were $100,000 and your overhead was $50,000, you have a net of $50,000. And we take 7.5% of that